going to deal with the position in Sri Lanka. As you know, obviously there has been a conflict in this country, in Sri Lanka, which obviously had its ethnic connotations to it. I'm not going to really deal with that part of it, but if there are any questions, I will certainly answer those questions, because the wider issue is how do we prevent such situations from occurring again. And the sad fact is that in Sri Lanka we are now facing a situation where we need to address this already. Just I would say just 3 years after sort of the end of cessation of hostilities, we are already facing a situation where we need to address the protection of minorities again. Basically, Sri Lanka is a state party to the ICCPR and also conventions on the protection of rights of minorities. As far as the legislative framework goes, from the very first constitution, which was the Socio-Legal constitution in 1947, while there were no fundamental rights set out, one of the rights that was set out was the protection of minorities and the protection of religious minorities. And this protection has been carried through the constitutional process. And in the present constitution, which is the constitution of 1978, the protection is really guaranteed by in the fundamental rights chapter in Article 12 in the equality provisions. In addition to that, to dealing with communal violence, it is essentially the basic criminal law of the country that needs to come into play. That's the Criminal Procedure Code and the Evidence Ordinance. Unfortunately, as we discussed before, we don't have a witness protection bill, which is one of the biggest factors impeding any form of inquiry into past and possibly current events that are happening in Sri Lanka. I will just deal with two situations that, as far as the judiciary's response is concerned, with regard to violence against minorities, there is nothing perhaps significant that can be stated, or there is no particular case that can be referred to. But generally, the courts have been active where there has been sort of overt acts of aggression. The courts have generally sought to be aggressive, but there has been no form of judicial activism in that sense. The two sort of instances which I just would like to highlight is sort of way back in 2000, when a proposal for an anti-conversion bill came into place. The sort of social background for the anti-conversion bill was that a lot of the majority Buddhists and Hindus were converting to Christianity or were being converted to Christianity. And in that background, there was a call by some for an anti-conversions bill. They tried to base it on certain models that were also present in India, I believe. And irrespective of the legality of the bill, which was ultimately certain provisions were declared unconstitutional, what surrounded the bill was that there was a sort of a building up of hate speech and also attacks aimed at certain religious places of worship. And with regard to the present situation, I think the cessation of hostilities came in May, about 3 years back. And after that, there has been a gradual sort of rise of hate speech and violence against against people of the Islamic faith or the Islamic religion. The background to this was that there is an organization called the Bodhu Bala Sena. Roughly translated, it means army of Buddhists, but please don't get me wrong, it is not representative of all the Buddhists in Sri Lanka. It is only representative of its membership. And the first issue that they took up was with regard to what we call halal certification. All products in Sri Lanka, generally food products, get a certificate that it is halal certified from an organization called the All Ceylon Jamiatul Ulema. And practically across the board, all products used to go, or all retailers used to get this certification. And certain groups felt that this was wrong and that they shouldn't get this, that this payment was actually false, and that the retailers should produce for the entire market, and that if certain people wanted to produce for people of Islamic faith, they could specially produce it, but there was no need for all the products to carry the halal certification. So that was really the beginning of this, of the issue, of where really it came to the surface and where people saw it. And of course there was no, ultimately it was solved amicably. The Al-Sila and Jamiatul Ulema decided not to issue any certificates unless it is for import purposes, and the matter was solved. Thereafter what happened was that there have been sporadic sort of attacks on places of worship, and we discussed in the earlier session the reasons or sort of the factors behind the success of the Gujarat cases. And with regard to Sri Lanka, the problem is that firstly the National Human Rights Commission is very weak, and so I don't think we will have the sort of background or reports that the people working with the Gujarat cases had from a state institution. So that institutional background is not present. The second factor of success in the Gujarat cases was witness protection, which is something we still don't have. Even in the local commission that was appointed to go into the conflict, one of the recommendations was that there needs to be witness protection. There was a draft witness protection bill, but it has not seen the light of day. So even at present, one of the biggest problems is the lack of protection for witnesses. And also with regard to trials being time-bound, there is a problem with the entire criminal justice system. That's not related really specifically to acts of violence against minorities. It's a problem with the entire criminal justice system, and that there are long overdue delays in the system itself. One of the positive aspects with regard to litigation in this area is that there are groups coming forward to represent parties and to ensure that the prosecutions happen properly. For instance, it's not related to violence against minorities, but there has, about 3 months back, a mass grave was discovered. It was from the 1987 period, and it's believed to be Sinhalese youth who are being killed and buried there, where the Bar Association went before the magistrate and got themselves and intervened as a party to the case, and the intervention was allowed by the magistrate. So there is now a culture building up of parties intervening and assisting courts and bringing matters and assisting in the prosecution. But other than that, there is a weak legal infrastructure with regard to dealing with violence against minorities.
Thank you very much. So now we move on to Bangladesh. Fanima Qureshi, you have 9 minutes.
Thank you very much. Can you hear me? By the Constitution of Bangladesh, there are many rights guaranteed, many laws in our country, but the problem is those are not implemented properly. There are some articles which protected the minorities, like freedom of religion. Secularism was one of the most important fundamental principle of our constitution. But recently, by the Supreme Court, Appellate Division of Supreme Court, they came up with an amendment which says that vital changes, which changes the very nature of our constitution. And the parliament again came up with further amendment which says that the religion of state should be Islam. There are a maximum number of people belong to Islam, Muslims, so this affects the minorities regarding their inheritance of property, their rights for the overall protection, including their family matters. Secularism, when this is the most important essence of our constitution, and when it has been taken away, that hurts the very feeling of the tribals, those who are living in our hill tracts areas in Chittagong, Sylhet, Mymensingh, and many other places, and including the Hindu and the Christian communities in our country. It's been a long time. We have been asking to have a comprehensive law regarding family matters. Like for Hindus, we have Hindu law. It's always covered or governed by the personal law, and that brings some sort of conflict in our law. For Christians, it is impossible to have a divorce, but when it is a Muslim, it is very easy to have a divorce, and the same thing happens to the Hindus. In our country, what we have been facing, that because of this kind of oppression, even in the schools of our tribal areas, the mandatory language is Bangla, where the mother tongue is not Bangla. They speak in a different language, the tribals. And regarding the Abandoned Property Act, this is a huge controversial area in our country for the Hindu communities. And whenever we come up with some sort of litigations before the Supreme Court, it's always a kind of a political issue rather than a general issue. It's treated in such a way that it doesn't show that we have our rule of law or independence of judiciary. Earlier, when I was talking before you, day before yesterday, I told that independence of judiciary means the mindset of the judges, whether they are working independently. There is a saying that we have to